Thank you, Mr Chair. The ACT Party has a number of amendments to this part of the bill and a number of issues to raise. And, Mr Chair, let me start by this first call by saying I hope that we have the opportunity to raise those points during this debate this evening and as it continues into tomorrow on this part. I want to talk specifically about two clauses. Clause 14, which runs to 1.5 lines, Mr Speaker, and Clause 17. But before I address those two clauses in this call, sir, on Part 2, there are a number of points that I need to quickly respond to. Sir, this part started with the introduction by Mr Finlayson. And Mr Finlayson was, the Honourable Christopher Finlayson, the Minister, was at pains to point out that New Zealanders would have access to the common marine and coastal area, that it was never an issue and had never been an issue, but notwithstanding that, he was prepared to succumb, if you like, to the pressure and the urgings of the ACT Party to amend that clause and make a specific provision there that the access to the common marine and coastal area was without charge. In making those comments, Mr Finlayson took the opportunity to take aim at my colleague Hilary Calvert, a very personal and direct and hurtful aim, sir, and I'm very sad, sir, that Mr Minister feels he has to stoop to those levels. And I acknowledge the comments of Materia Ture, who rose to her feet immediately after those remarks were made. Sir, I'd also like to comment very quickly on the point that Kelvin Davis made during the comment, and it's interesting that during his debate he was subject to interjections. I think it was from Mr Quinn. Mr Quinn said to Mr Davis, he taunted him with, "Why didn't you say this during the debate? Why didn't you say this in select committee?" Well, I suspect, Mr Chair, Mr Davis would have liked to have said that in select committee, but, sir, what this Parliament is ignoring is the government used its majority on the Maori Affairs Select Committee to ram this bill through, sir. And, sir, we have a report here from the Maori Affairs Select Committee, and, sir, the official report of the Select Committee, sir, is simply one page. The official report from the Maori Affairs Select Committee is one page, sir. And attached to that, sir, is a...
Order. These cross interjections, too loud. Calm it down. Honourable John Biscone.
Thank you, Mr Speaker. Sir, we then had the Labour Party, the Green Party and the ACT Party minority report. And, sir, what then followed was 40 pages of recommendations from the officials. And normally what would happen, sir, is the Select Committee would expect to see those recommendations incorporated into drafting. That an amended bill would come back before the Select Committee, and the Select Committee members could actually consider that, sir, at the Select Committee, look at the various amendments, look at what was best, what wasn't best, sir. And the reason that this debate, Mr Chair, is going to go on for so long is that the government used its majority to shut down that debate, shut down people like Mr Davis, who was a member of the Maori Affairs Select Committee, and so we now have to debate those, sir, on the floor of this House. Sir, let me move now to Clause 14 of the Marine and Coastal Area Takutai Moana Bill, sir. And I'll just find it here, Mr Speaker, because that is the essence of this bill. Clause 14, sir, in Part 2, the part that we're debating right now. Sir, and people listening to this debate on television, on the radio, might ask, what does Clause 14 say? Well, very simply, sir, it says the Foreshore and Seabed Act 2004 is repealed. The Foreshore and Seabed Act 2004 is repealed, sir. And that is why we're here tonight. And, sir, I'd like to repeat again, sir, a claim I made earlier this afternoon, is that the ACT Party has been entirely consistent on this issue the entire way. We are talking about property rights, we are talking about access to justice, access to the courts, sir. And that is something that we absolutely support the Maori Party in. We don't believe that this bill does that. We don't believe that this bill is the right response, sir, but we absolutely support the Maori Party in the repeal of the section of the Seabed and Foreshore Act 2004, and we absolutely stand up, sir, for the right of iwi and hapu, Mr Chair, to go to court. And, sir, the ACT Party, I suspect, with the national opposition at the time, would have been the only members in this Parliament who would have supported Tariana Turia when she first took her lone stand. But, sir, so what I want to make absolutely clear, the position of this bill is that we want to see that Act repealed. Having said that, Mr Chair, it's important to understand what the decision in Ngāti Apa was. And the decision in Ngāti Apa was that iwi have the right to go to court. There may or may not be unextinguished customary title, customary rights out there, and iwi have the right to go to court. And I can't emphasise enough, Mr Chair, that the appeal court did not say there was unextinguished customary rights, didn't say there was customary title, it simply said there might be, and iwi and hapu have the right to go to court, sir. Now, one of the reasons, sir, that we object so strongly to this bill, and we're going to fight against it so hard, sir, is that we believe that what this bill does, sir, it makes things so much worse. The Attorney-General constantly calls out codification, codification. We've got to put the rules in here so the judges know what to do. Well, sir, in actual fact, what is happening here is he's actually making it much harder for the judges. He's actually making it much harder for the judges. The judges have the option, if the government had simply repealed the Seabed and Foreshore Act 2004, and that's all they had done. Alternatively, I think as Mr Parker has suggested, the Act be repealed, that there be provision for claims be taken to the High Court, and that access to the Common Marine and Coast Area be guaranteed. The ACT Party could also have supported that, sir. But what has happened, sir, is that the proposal is to repeal the Act and to put in place a series of tests for the granting of customary title, sir. And those tests go beyond anything that has been provided for in any Commonwealth court in the world. There has been no successful cases in the United Kingdom, there have been no successful cases in Canada, and there have been no successful cases in Australia. And in fact, Mr Chair, it might interest you to know that the only claim that was brought for customary title or ownership of the seabed in Australia was actually lost. It was actually lost. And so the National Party has the gall to put out there that what this is doing is building on common law, building on precedent, building on decisions that have already been made in other countries around the world. Well, let me repeat again, sir, that there has been no legal decision, no judicial decision that passes customary title, ownership, because we're talking something about akin to ownership, to a customary title applicant. And, sir, the reason that the ACT Party so strongly opposes this is that what the government is doing, the government is assuming that the courts are going to go away and grant a customary title over large areas of New Zealand's coast, and so they're putting in tests in the eyes of the government to reduce what is granted. In actual fact, sir, the effect of this will be to substantially increase the areas that may be transferred into customary title. And when I say transferred into customary title, sir, I mean the benefit of which is transferred from all New Zealanders to a select iwi, sir. And I guess that brings me on to Clause 17 of this part. And Clause 17 says, sir, that relates to the continued Crown ownership of the minerals. And what this clause says, this clause provides that notwithstanding that a applicant group may gain customary title, the ownership of all nationalised resources, which is petroleum, gold, silver, uranium, stays with the property of the Crown. Now, I guess there's a couple of issues to that, Mr Chair. The first issue is, well, what doesn't? What hasn't been nationalised? And, sir, clearly one of New Zealand's major resources that hasn't been nationalised is iron sands. This country, sir, has some 600 billion. The Ministry of Economic Development have estimated that there's some $600 billion, sir, to $1,000 billion. That's $1 trillion worth of iron sand, sir, off the coast of New Zealand. Now, sir, a large part of that lies off the coast of Taranaki and the Waikato. Now, you might say, well, sir, that belonged to iwi in 1840. That belonged to iwi in 1840, sir. But one of the fallacies of this bill, sir, is the common marine and coastal area. Mr. Chair.
I have the Honourable Shane Jones.